Good afternoon, everybody, and welcome to this talk organised by Two Temple Gardens dealing with care and attendance claims. I'm Harry Trusted. I've got a lot of experience in high-value clinical negligence and personal injury actions, and I've been an editor of Facts and Figures for many years, and I'm the secretary of the Ogden Working Party, so I have some knowledge of the detail of how these quantums are put together. I'm also joined today by Alex Ivory. You will hear from him dealing with two recent cases which we think give you an illustration of how and why expert evidence can be deployed successfully to achieve the best result, whether you're for a claimant or for a defendant. Beginning at the beginning, it's worth asking what attendance, what care means. It was described by Lord Bridge in Hunt and Severs as anything that could be described as extra attendance when someone's had an injury. And there is quite a wide definition of what might be within a care and attendance claim. It can be something like assisting with washing and dressing. It can be making meals, getting the shopping, various kinds of DIY jobs, gardening, assisting with mobility, for example, helping someone up and down stairs, driving to get someone to hospital or to see a doctor or in some other way helping them. It can be psychological support, and it can be visiting in hospital if you're giving some practical assistance while you are there. All of those things are within what we call a care claim. There are two possible ways of compensating. One is the so-called non-commercial or gratuitous claim. That arises where a family member or friend is providing the service. The alternative is commercial care, where the service is being provided by a stranger who's being paid to do it. And those two broad categories disclose slightly different problems of compensation, which we'll see in a minute. Before we get to that, though, I just want to look at a few areas of practical support which I think can be usefully offered in any case where there is likely to be a significant care claim. A claimant solicitor, if possible, should see the claimant at home. And if possible, should see the claimant with close family members who are involved in providing the care in question. That may be obviously a spouse, or possibly parents, or possibly children, depending on the age of those involved. I would also say that if you can ask counsel to come along to that meeting, in a big case, that is often a very useful step. It means that the family know who the legal team are. You won't, of course, just be talking about care, you'll probably be talking about other aspects of the case. But it gives the lawyers a three-dimensional sense of what's really involved and how somebody is coping day to day. The claimants team will also want to ask permission to approach friends and wider family so they can get statements in support of the claimant's care needs. And they will also encourage the claimant or the claimant's family to keep receipts for that part of the care which is being provided commercially. For example, if a cleaner is being paid to come in and help since the accident. Videos and photographs can be useful to both sides. A defendant is unlikely to be able to get useful witness evidence from friends and family, but if it's suspected that the claim is exaggerated or that the claimant's needs are not quite as great as the claimant's care expert suggests, a video may be useful evidence to persuade the court or the claimant's advisors that their claim is over-egged. Even the claimant can sometimes make use of a video. Of course, the video is always going to be taken with the claimant's knowledge, but if you want to show that somebody has difficulty getting upstairs or difficulty getting themselves up from an armchair or a sofa, it may be helpful to have a video to show exactly what is happening. Whoever you're representing in these cases, remember that accuracy is very much the name of the game. A claimant advancing a case which turns out to be inaccurate runs the risk of the whole claim being struck out on the basis that it is dishonestly advanced. Even if that doesn't happen, inaccuracies will damage the credibility of the case. And similarly for the defendant, it's important to put forward figures and estimates that are realistic and properly calculated. I shall be talking about care experts and what they can do, and so will Alex in the second half of this presentation today in relation to the two specific cases he will cite. You can't overemphasize that care experts in a big case are fundamental to your prospects of success, whoever you're representing. Choose with care. Find someone you know and rate, and if you can't get someone who you know, ask around from trusted colleagues and see whether or not they can give you a suggestion. That choice is likely to be determinative of the success or otherwise of your action. In relation to preparation generally, there are a few other things I would say that are worth bearing in mind at an early stage. First, if you're representing the claimant, be realistic about how long the case is going to take. If liability is denied, they need to understand that they're not going to get financial help until liability has been resolved, either by settlement or trial. If liability is agreed, you can apply for an interim payment. And if you've got a significant claim for ongoing care and you don't apply for an interim payment, that obviously suggests that you're not really dealing with a care need which you assert. Even worse, if you get an interim payment and it's not actually used to pay for the care, that suggests that the claimant may not really be serious about getting the help which they claim. A point for defendants: if an interim payment is provided and does give the claimant a better quality of life, you may find that it pays for itself, because if the quality of the claimant's life improves, he or she may find that their psychological symptoms tend to improve as well. They may even, for example, get back to work. So a prompt interim payment and rehabilitation support may actually be in the defendant's interests as well as the claimant's. Now, I want to come back to non-commercial care claims, or gratuitous claims as they're sometimes called. As I've said, this is care provided by friends and family members, and there are one or two specifics that you need to be aware of. First, if the tortfeasor has provided the care, the claim, I'm afraid, fails. So if the husband's driving the car which hits a tree and the wife is injured, he provides her care, there is no claim. Secondly, remember that a care claim for gratuitous care is brought on the basis that the claimant holds the money in trust for the person who's provided it, whether it was a friend or a member of the family or whatever. Again, there's a little niggle here you need to know. If, since the provision of care, claimant and carer have fallen out, the court may find that as a matter of reality, the money claimed on trust isn't going to find its way to the carer. That was the position in ATH and MS. In that case, a couple had an acrimonious divorce after the care was provided. Finding money wasn't going to go to the carer, claim fails. Remember, though, that any extra domestic service covering quite a wide range of things will be sufficient to qualify for a care claim, and the authority for that usefully is Jambroni and Sunworld. And lastly, care in hospital. You can claim for care in hospital if, but only if, the relatives or friends were actually doing something to assist the medical staff. Simply going along and having a chat by the bedside, I'm afraid, doesn't qualify, per the case of Huntley and Simmons. How do you value non-commercial care? Well, in smaller cases where you don't have an expert, you need to make an estimate of the number of hours which have been spent or are being spent. It's useful if you can get the claimant or the claimant's family to keep a diary which will substantiate those hours. It's helpful to have witness statements from family members, not just the people who provided the care, but perhaps other people who can evidence that it was given. If you are for a defendant, the absence of such evidence may make you inclined to doubt the accuracy of the number of hours allegedly spent. What is the appropriate hourly rate? Well, the usual commercial valuation now is the National Joint Care Council Spinal Point 2. And if you look at page 397 of the current edition of Facts and Figures, you can see all of those rates since 1998, which will allow you to form an estimate in the case whether this is a significant past claim going back several years. The present rates are £10.60 for basic and £39.92 for aggregate hours. What does basic and aggregate mean? The basic rate is paid on a Monday to Friday 9 to 5 basis. So if somebody has just required a bit of care which can be easily provided during the week, that lower rate is what will be recovered. The aggregate rate, which is quite a lot more, about 35% extra, is paid if care is provided in antisocial as well as social hours. In other words, if care sometimes must be provided in the night, somebody needs assistance then, or at weekends and bank holidays. So that's a very significant point, which, as I've said, will be determined by questions of fact. And the courts have, in a number of cases, considered the contesting claims, and it's always been a matter of judicial discretion as to which evidence is preferred. So in Whiten and St George's Healthcare, the aggregate rate was awarded for non-commercial care, looking after a disabled child, but in Hayden and Maidstone Trust, only the basic rate was recovered because the judge wasn't persuaded that the care was really provided at antisocial hours. Now, there is a discount applied to those hourly rates. The discount is applied because a person receiving money for non-commercial care, the actual carer, does not pay tax or national insurance on that money. So there's a discount. The discount is almost always 25%. That was the discount applied in Whiten. But in the recent case of CCC in Sheffield, Mr. Justice Ritchie declined to impose any discount on a claim for parents looking after a badly disabled child. You're going to hear more about that case from Alex Ivory after I've finished. But the point to note for now is that that is quite a surprising departure from what had become a pretty well-established rule. We don't know at the moment whether the nil discount will be successfully claimed in other cases. But I would say that for the very large majority of claims, if you are looking to get a settlement at a JSM, which you usually will be, it is unwise for defendants to contend for a discount of a third, which they sometimes do, and it's unwise for claimants to make too much of CCC in Sheffield and claim a nil discount. 25% is pretty much the standard order of the day. Another possible means of valuing past non-commercial care is looking at losses of earnings if someone has stopped work for a period to look after an injured claimant. That is something which can be done, and it may be attractive partly because it's straightforward. If you can show that someone has, say, stopped working for 6 months and that was a reasonable thing to do, they would have earned a certain amount of money in those 6 months, and that's what they claim. There are 2 words of warning. First, you will not get an award which is significantly in excess of the hourly rates you would have claimed under the spinal point 2. In other words, if you are a merchant banker earning £1 million a year and you give up work for 6 months, I'm afraid you can't claim £500,000. All you can claim is what a carer would have been paid for 6 months' work, which is a lot less than that. The other catch is that following the decision of McMenamin and Farrell in 2017, the 25% discount is applied to the losses of earnings calculation. In other words, even where you're claiming a net loss of earnings, you still deduct the 25% because it's still a non-commercial claim. One other point I'll make about past claims in care is that you need to be aware that the carer's allowance, which is a benefit, a state benefit paid to family members who care for disabled relatives, is not within the CRU scheme. Now that means that the benefit can be deducted by the defendant from the claimant's non-commercial care, because since it's not within CRU, if the claimant had both the care claim and the carer's allowance, there would be a double recovery. And the case on that is Massey and Tameside. So you need to watch that, whether you're for a claimant or for a defendant. Carer's allowance is netted off the claim, additional to CRU. What about past commercial care, where the claimant has actually paid somebody to do either some sort of care job or cleaning or cooking or gardening or whatever it is? This is usually a relatively straightforward thing. If you've got receipts and you can show that someone came in and gave help and was paid a certain amount of money, then that should go through without too much debate, providing it's agreed that there was a need which arose because of the tort. A couple of words of warning there. Of course, you want good quality evidence about what's happened, receipts, witness statements, and so on. And secondly, of course, the costs need to be reasonable. You can't just claim some figure which is obviously way in excess of a sensible market rate. Care experts advising in a case of this kind, instructed pursuant to CPR Part 35, are unlikely to be allowed by the court unless the value of the care is at least in 6 figures. Smaller cases are unlikely to justify the expense of the care report. But if you've got a care expert, that may be very useful in a large case to estimate just how much time the family has spent. A further complication that can arise is that if you have a child injury case, you have to bear in mind that small children need a great deal of care and attention anyway. Your claim will only ever be for the additional care which has been caused by the injuries for which they claim. A care expert will be able to work out what the but-for care would have been and deduct that from the time actually spent by the parents. Good care experts will facilitate the settlement process by coming to realistic and sensible figures on both sides so that it's possible to try and formulate an agreement. What about future care? Well, future claims, of course, are always so much more difficult because there's a great deal of speculation about what may be needed, how it may be provided, and quite how the money is going to be paid and in what form. Smaller cases of non-commercial care may be dealt with on a kind of in-the-round estimated basis. So in Fleet and Fleet, Mr. Justice Mackay in 2009 allowed £1,500 a year to cover the costs of gardening and DIY, which the deceased's husband would have been able to do but for the tort. And in Zambada and Queensborough in 2013, about £2,000 was allowed for a slightly wider range of domestic tasks which would have been done. So if you've got a modest case, you may be able to produce a sensible estimate of ongoing costs, ongoing care, DIY, whatever it is, which again is capable of agreement between reasonable parties taking a sensible view. And of course, if you've got past costs and invoices, so much the better, because that's likely to give you some sort of sensible guide to what might be the right figure for the future. Beyond smaller cases, there is a question about whether or not family care can continue or should continue where you have someone with more serious injuries who requires a higher and more personal level of care. My own view is that it is rarely appropriate or attractive and is unlikely to find much favour with the court. If somebody needs 5 or 10 hours of care a day, that's a great deal of help, and they're clearly very badly injured. If your care claim is constructed on the assumption that some family member is going to provide it, there are, to my mind, a number of objections. First of all, you're effectively obliging that family member to help, which they may or may not want to do. But even if they do want to do it, you have to bear in mind that at some point they may become infirm, they may die, even if they're younger than the claimant. They may simply die young, or they may walk out, and there's nothing that the claimant can do about that. Remember too that generally, not always, but generally people prefer to have personal care provided by strangers who are paid rather than by their mum or their dad or their child or whoever. It's less embarrassing and it's actually a more successful way to run family relationships. And last but not least, in a case which involves significant and complex care, the paid carer is going to be trained to do it. And they are likely, other things being equal, to make a better job of it. I should say that I would accept that you do occasionally have cases where the family are very determined that they don't want paid care. But in my view, every effort should be made to persuade them, if there's a badly injured person, that really the only secure way to provide the care in the future will be on a commercial basis. And if one was trying to get a settlement approved, I think it would be difficult to persuade a judge that a non-commercial care solution was likely to work in the longer term for the reasons that I've just given. Moving then to commercial care, well, it's worth saying at the outset that there are two formulations of commercial care. The first is the direct employment model, where the family employ the carers themselves. There'll be a case manager who will usually oversee things, and the idea will be that the contract is with the family or with the trust which has the damages, and there won't be any intermediate agency. That is usually at the moment working out at about £15 an hour, although rates vary wildly. An agency-based care plan, where the agency provide the carers, there's much less case management, and the agency is responsible for finding, firing and hiring everybody. The agency care rates can be anywhere between £20 and £40 an hour, highly variable depending on the exact nature of the need, the amount of care required, and importantly, the location of the claimant. Some parts of the country are much more expensive than others. If you have a case which requires significant commercial care in the future, you will need a care expert. The care expert, if they're any good, will research local rates, will provide reliable estimates of what is involved and what it costs, and will take account of the specific needs of the claimant and the claimant's family. And of course, if they're the defendant, they'll make sure that the rates are not claimed at an excessive or unrealistic rate. You will have cases in which the future care costs vary. For example, a child with cerebral palsy will usually be entitled to free education until the age of 19, which means that during the time they're at school, there will not really be a care need as such, and the cost will increase after the age of 19. A paraplegic may be comparatively independent until the age of 60, but then needs significantly more help with transfers and other support from that sort of age onwards. And as a final example, a below-knee amputee may manage without a wheelchair and just with prosthetics until about the age of 70, but at that point they will deteriorate and need help and more wheelchair access, especially when they're mobilizing outside. I'm just going to give one example of the multiplicand calculation. For free schooling up to until the age of 19 or 20, and generally the last 10 years of life involves more extensive care. So my example is a child with a life expectancy of 60 years, now aged 10. The next 10 years, ages 10 to 20 is 200,000 a year. Ages 20 to 60 is 250,000 a year. Ages 60 to 70 is 300,000 a year. So they're round numbers, they're just intended to give you an indication. Let's look at how you approach the multiplier. Well, first of all, you've got a total life expectancy of 60 years. You can look up in Ogden %. The first 10 years, you can also find in Ogden Table 36 of 10.13. So that's the first 10 years. The next 40 years, you take the 40-year period from Ogden Table 36 and you enhance it slightly for early receipt from Table 35 to produce 43.13. The final chunk of 10 years, you take the total of 64.74, which is your life multiplier in this case, you deduct the two other multipliers you've already derived, and you have a residual figure of 11.48. Now I should say that the slides that go with this talk will be sent to everybody, so you can look at all of this there. Into the correct calculation, you end up with a claim, a future care claim of just over £16.25 million. And that is the sort of figure which those claims will generate for future care and case management costs for badly injured people. And that's why care claims are a major part of personal injury and clinical negligence practice, because of the value of the claims and, of course, their importance to both sides going forward. What is a periodical payment? Well, it's a regular annual sum paid by the defendant to the claimant, usually as long as the claimant's alive. It may vary up and down if the needs can be agreed, as per the previous example, and there is an annual variation in costs depending on what happens to hourly care rates, which are measured by an index produced in the annual survey of hours and earnings, and the relevant number is 6115. So you get an annual sum of money uprated by reference to the index, paid usually as long as the claimant lives. Big advantage, you don't need to worry about life expectancy because you get it as long as the claimant lives and not beyond that. Big advantage, you're not concerned with investment returns because you get your money no matter what happens to the stock market. Big advantage, you don't pay tax on it because there's a special tax exemption agreed with the Inland Revenue. Of course, it's not perfect. Things may change unpredictably, but generally, for those claimants who are eligible for it, a periodical payment is a really good solution. And it may be attractive to the defendant if there's a big issue on life expectancy. It's worth saying, though, that for some cases, you can't get a periodical payment. You will only get a periodical payment if the defendant is either the government, such as the Health Trust, or an insurer authorised by the financial authorities. Generally, British insurers are so authorised, but foreign insurers are not. You can't have a periodical payment if there's a limit on indemnity because the limit may be exceeded if the claimant lives a long time and or if there is high inflation. And last but not least, it's difficult to make a periodical payment work if you're only receiving a percentage of the full liability claim because you're going to have to rob Peter to pay Paul, and often it's just not possible to make a periodical payment successful if there is a division of liability. A quick word about case management. As I've said, if you go for the directly employed model, then you will need case management, which is now coming in at £110 an hour or thereabouts. In Swift and Carpenter, which is best known for the Court of Appeal decision on accommodation, Mrs. Justice Lambert, although she accepted that the claimant had a very significant leg injury, which was bad enough to warrant a change of housing, did not accept that the claimant required case management and was of the view that the claimant herself had the ability to run the care package. You'll notice, of course, that that was a leg injury case and not a brain injury case, so the claimant was able to manage her own life to that extent. Childcare is another subheading we should just look at quickly. If you have a situation where there are parents, one of them dies, the person who dies normally provides the childcare, the person who is trying to stay and work to support the family can claim for the costs of the childcare to replace the injured or dead partner. And in Swift and Carpenter, the case I've already referred to, such a package of care was allowed. It's worth saying that this can be also a substantial head of loss. The cost of a live-out nanny in London is now about £40,000 a year. So you can see that you can get well into six figures very quickly with a childcare claim of that sort. Finally, just a couple of specific problems which you may meet. Do be aware that if the claimant had care needs anyway, those care needs cannot be part of the claim. You can only claim for the additional costs of care which are caused by the tort. And the leading case on that is Reedy in Staffordshire, and I think one of the cases that my colleague Alex is going to talk about also involved that problem. Second little point, residential carers. Sometimes, for the right claimant, having the carer live in the home can be a good solution. It can be cheaper for the defendant and more convenient for the claimant. But it's got to be the right case. And as a matter of fact, the court has to be persuaded that the claimant would accept it and that the nature of the injuries is such that the live-in care package is going to work. But in Swift and Carpenter, for example, that was accepted and the award was £65,000 a year. Finally, be aware of the difference between waking and sleeping carers. A waking carer will be required to get up more than twice during the night to provide care, and that care will be charged at the full day rate. A sleeping carer, which will be charged at a lower rate, will not be required to get up more than twice during the night. But of course, if you have those claims on a lifelong basis, you are looking at a very substantial damages claim. Thank you very much for listening today. I'm going to hand over now to Alex Ivory, who's going to look at two specific recent cases and look at the lessons which we can learn from them.
Thank you, Harry. Care and assistance claims came under the spotlight in two High Court judgments handed down earlier this year. They're two contrasting judgments from perhaps two contrasting judges. So in late June, we had the decision of Mr. Justice Cotter in Scarcliffe and Brampton Valley Group Limited. Mr. Scarcliffe's claim was that he developed a chronic post-traumatic lumbar pain condition as a result of an accident he'd suffered. He said it left him unable to work, care for his children, or indeed assist with household duties. And as a result, he said he needed significant care on a daily basis. His schedule of loss saw a sum in excess of £6 million. At trial, he ended up recovering just £275,000. That's around 4.5% of the sum sought. So this was a case on quantum which went rather badly for the claimant indeed. Just a few weeks later, Mr. Justice Ritchie handed down his decision in CCC and Sheffield teaching hospitals. CCC was a cerebral palsy case. The claimant was 8 years old at the time of trial and she was very seriously disabled. Liability was admitted by the trust and the trial proceeded on quantum only. The claim was pleaded at just over £9 million and the result was a good one for the claimant with an award of just over £7 million. Both of these decisions provide helpful lessons for claimants and defendants alike. Not least, they act as a rather sobering reminder of just how wrong expert evidence in care claims can go. There's 5 key points I'm going to go through in turn. In the first place, it's making sure your care expert has appropriate expertise. So in CCC, the defendant's care expert was a Mr. Chakraborty. He was described as a consultant occupational therapist. And in fact, he also provided the defendant's occupational therapy evidence. The problem was he had no apparent experience in being a case manager, putting together a care package, recruiting or managing carers, or in terms of their training. By contrast, the claimant's care expert, Maggie Sargent, had real-world experience in case management, and in particular the management of maximum severity care packages. And so Mr. Chakraborty's lack of experience led to what is rather stark judicial comment from Mr. Justice Ritchie. He said, "I consider that Mr. Chakraborty is not an expert in constructing, designing and managing care packages for children with cerebral palsy. He did not have case management qualifications or experience, and I do not consider that he was acting within his CPR Part 35 responsibilities." So, with that comment, it's going to be of no surprise that Mr. Justice Ritchie preferred the evidence of the claimant's care expert, Ms. Sargent. But this is my first point. There's an imperative not just to have a good and reliable care expert, but to make sure that your care expert is suited to the particular case. A crucial question is going to be, well, do they have relevant experience or qualifications in assessing and costing the care needs of this particular claimant? And so experts in a cerebral palsy care case might well be different to the sort of care expert you want in a psychological injury case. The care expert's particular skills have to marry with the particular problems of the case in issue. Staying with CCC, Mr. Chakraborty came in for further criticism for his report being out of date. Mr. Chakraborty had visited the claimant just once in March 2020, and at that time the claimant was 5 years old. There was then a gap of over 2 years between the date of that visit and the date of the final report. Mr. Chakraborty never visited again, nor did he provide a second or updated report. That contrasted with Ms. Sargent, the claimant's expert, who'd visited the claimant twice and including before her report in December 2021. So Mr. Chakraborty came into criticism for his report being out of date. On first glance, this might seem a bit unfair because his report is actually dated after Miss Sargent's. But what was really relevant for these purposes was not the date of the report itself, but the date of the visit at which the information underlying the report would have been obtained. And so because the claimant's expert had visited over a year after Mr. Chakraborty, it was Mr. Chakraborty's expert evidence which was relatively out of date. As a point of strategy, what would seem important then is less having the most updated report as possible, but making sure it is at least as up to date or more up to date than the other side's. Because if a judge is looking for a reason to prefer one set of care expert evidence over the other, the fact that one is more up to date provides quite an easy reason for the judge to decide on that preference. The third point, which comes from these cases, is marrying the care expert evidence with the medical evidence. In Scarcliffe, Mr. Scarcliffe's case was that as a result of this accident, he was suffering from this chronic pain condition and its debilitating effects. The defendant's case was that Mr. Scarcliffe, in fact, had a pre-accident history of back pain arising from a degenerative spine condition, and that even but for the accident, his spine would have continued to deteriorate and he would have developed a pain condition in any event. Mr. Justice Cotter ended up accepting the defendant's case, in effect finding that Mr. Scarcliffe had only suffered an acceleration injury. It's not uncommon to see defendants running partial causation denials, and then which in turn leads to there being these primary and secondary cases pleaded in quantum. What that means in terms of care expert evidence is it has to be robust. So it should reflect the range of medical expert opinion in the case. Not least, that's because it's not for a care expert evidence to make a determination on which medical expert evidence is to be preferred. So good care expert evidence will deal with care needs and costings in the primary case, but also say, well, if the other side's medical experts are correct, here's the costings for that. That gives the care expert an air of independence. It makes clear to the judge that they know what their expertise is and where it stops. But it also means that if at trial you lose on your primary case on causation, your care expert evidence is still directly on point, and the judge isn't tempted to turn to the other side's expert evidence because that's the only one which deals with the scenario that's now in issue. We come to my fourth point, and it's probably the most important one in terms of care expert evidence. The devil really is in the details. If you take some time to read the judgments in Scarcliffe and CCC, there's certainly a sense of Schadenfreude you get to experience, because the care experts came in for quite obvious and damning criticism and errors that they'd made in their reports. In Scarcliffe, Mr. Scarcliffe's care expert was a Ms. Lewis. And again, I'm going to read from Mr. Justice Cotter's summary of her expert evidence because it gives a flavour of just how badly it went. Mr. Justice Cotter said, Ms. Lewis, who gave expert evidence as to care, will have found it a very uncomfortable experience indeed. As obvious as mistakes and omissions were pointed out, significant parts of her evidence were unsatisfactory and or ill thought through. I find that very concerning indeed. I'll give some examples of the obvious and basic errors which were made. So Ms. Lewis failed to appreciate in her first report that one of Mr. Scarcliffe's children had been born at the time she was writing it. It was rather a glaring omission. As another example, Ms. Lewis factored in future care for supervision of the children when getting dressed, and also for the school run. These are normally perfectly reasonable items to factor in a care claim. The issue is she'd factored these into a time period well into the children were in their mid-20s. So quite obviously they didn't need help getting dressed or going to school at that point. There were also just issues with sense and reality checking. In terms of the rates Ms. Lewis had provided, they were just too high. They resulted in salaries for the location for carers, which when one looked at it just were clearly wrong. And they seemed to be just based on her own agency's rates. And for that reason, they were not adopted by the judge. Similar failings were identified in terms of paying attention to detail in CCC in Mr. Chakraborty's evidence. A lot of his evidence seemed to be based on online research. So in terms of some hourly rates, he'd relied upon an advertisement, a single advertisement for a support worker in respect of an adapted vehicle for the claimant to travel in. He'd again done what looked like online and quite superficial research, and he managed to recommend one vehicle which was then out of production. And clearly it's not going to be satisfactory if experts are just doing Google searches and that forms the basis of their expert evidence. In a similar vein, and it's something which Harry touched upon earlier, Mr. Chakraborty assumed that the claimant's mother would continue to be a full-time gratuitous carer going forward. But he'd never checked that with the claimant's mother, whether this was something she wanted or planned to do. And in fact, her evidence was very much to the contrary. Now, some of the mistakes that I've talked about perhaps fall into the silly mistakes but easily rectified category. So if you're recalculating future care costings and you need to adjust the period because of the children's ages, it's not the most difficult recalculation to do. The problem is, if those errors are only identified at such a late stage, when the expert is in the witness box, then they lose a great deal of credibility. And when there's a pattern of an expert making those mistakes in their evidence, a judge just isn't going to feel safe in relying on what the expert says in their evidence. So as Mr. Justice Cotter again put it in Scarcliffe, he said, "In my experience, the content of care reports is sometimes transposed directly into schedules and counter schedules by lawyers with limited critical analysis or challenge. A care expert should be able to fully justify any aspect of care therapy or equipment. Anything less is inadequate." And that brings me to my fifth and final point, because while care experts must of course deal with the detail and their conclusions as to need and costings must be logical and supported by a firm evidential basis, as lawyers, our job is to test and check that. It's imperative that independent judgment is exercised by solicitors and counsel. Why has the expert said this? What's the basis for it? What's the underlying evidence? Does it pass a simple sense check? Failing to do that in a case which goes to trial may well result in the disaster of having obvious and damning errors only being discovered before the judge in the courtroom, and a case previously thought good may collapse. Even if a case doesn't go to trial, at settlement meetings, it's not going to be good for you if the other side's representatives are pointing out all these errors in your experts' reports. Now, all of this is, of course, easier said than done. These are sometimes difficult issues. If there's going to be one takeaway from all this, it's that it's a mistake to just churn out what an expert in care has said. There is an extent of proper analysis and thought which needs to be applied to what they say. It may well be that their evidence needs to be tested in conference by counsel. That would definitely be a sure way to proceed in the higher value claims. Thank you very much for listening to Harry and I today. There will be slides going out after the talk, which will detail some of the things we have said.